أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. الحمد لله والصلاة والسلام على رسول الله وعلى آله وبارك وسلم. Dear students, Assalamu alaikum wa rahmatullahi wa barakatuh. I welcome you all to another video lecture of the subject business law. This is our video lecture number 9, and in this video lecture we'll start chapter number 5 of the business law, which is about the performance in breach of contract. This chapter consists of 2 lectures. First half of the lecture talks about the performance of contract, and the second half of the chapter discusses the breach of contract. So let's begin with the first topic, which is performance of contract. So what is meant by performance of contract? Performance of contract means basically the fulfillment of legal obligations created under a contract by contractual parties, by promisor and promisee. This is called performance of contract. Means when both of the parties, promisor and promisee, they fulfill all their obligations, means the rights and duties are fulfilled by both of the parties, where the right of the one party is the obligation of other party and the right of the other party is the obligation of the first party. When both of the parties fulfill their legal obligations under the contract, such a fulfillment of legal obligations under a contract is called the performance of contract. Now, contract comes to an end when both of the parties perform their legal obligations. We say contract is ended or executed. So when it comes to performance, we have to look at the contract or the promise within that contract, and then according to that we have to perform the contract. So there are 3 types of promises basically in a contract. So looking, first of all, we have to identify which type of promise exists in that agreement, in that contract, and then accordingly we have to perform. So when it comes to performance, the contracts are of the following types. There are contracts with single promises, there are contracts with joint promises, there are contracts with reciprocal promises. So there is a single promise contract, there is a joint promises contract, and third is there is reciprocal promises contract. Now we are going to discuss each category one by one, and we will discuss how each type of promise is performed in a contract, and who should demand the performance, and who should perform first and who should perform second, and who has the right to demand the performance of the contract. So these will be discussed here inshallah in this lecture. So let's begin with the first category. The first category is performance of single promise contract. We have to know what a single promise contract is. A single promise contract is a contract where there is one promisor and one promisee. One promisor, one promise, means on first party there is one promisor, and on the second side there is another promisee. Means there are 2 individuals, there are 2 parties, on both sides there is only single individual, right? On one side there is promisor, on the other side there is promisee. Who is the promisor? The person to whom the offer was made and he accepted the offer. That's called promisor. Who is promisee? The person who to whom the promise is made, or in other words we can say the person who made the proposal and then his proposal was accepted, right? So the person whose proposal was accepted or to whom the promise is made is called promisee, because a proposal accepted becomes promise, and the person who accepts the proposal or offer becomes the promiser, right? So to whom the promise is made becomes the promisee. So a contract where there is a single promisee and a single promiser, such type of contracts are called single promise contract. Now the question is, who should perform first and who can demand the performance? So the answer of the first question, who should perform first, is the promiser. Obviously the promiser has to perform its promise first, and after the promiser has performed his part of promise, then the promisee should perform. Now who can demand the performance? So obviously the promisee can demand the performance. Until and unless promiser does not fulfill his part of promise, he cannot demand from the promisee to perform. But promisee can demand the performance from the promiser even the promisee has yet not performed his part of promise. This is by law. So by law there are three types of people in a single promise contract who can demand the performance from the promiser. The first one is the promisee. Second one is the legal representative of the promisee. So who is the legal representative? Legal representative can be anyone who is given the representativeship by the promisee on a piece of paper, on a legal document. So legal representative is basically anyone who can present a legal document which shows the representation of the promisee, and from promisee he has been assigned as a representative. So such kind of people are called legal representatives, and they can also demand the performance from the promisee instead of the promisee. Third party, this is optional, and it's very rare case. Like in very rare cases, a third party can also demand the performance of a single promise contract from the promiser. So let's talk about them one by one now. The promisee can demand the performance of the contract. In normal situations, a third party cannot demand the performance, right? For example, Ahmad promises Bilal to pay 23,000 Afghanis to C. If Ahmad does not pay to C, only B can demand the performance, right? C cannot demand the performance, right? So if there is a contract between A and B, A is promiser, B is promisee, so only B can demand the performance from A to fulfill the part of his promise, right? And second is the legal representative of B, of the promisee. He can also demand the performance, but there are conditions. And what conditions? Condition is, in case of death of the promisee, his legal representatives can demand the performance of contract unless a contrary intention appears from the contract, or the contract is of personal nature. Sometimes the contracts are of personal nature, means the promiser has to do it itself. I mean, the performance in the contract is of personal nature, means the act that the promiser would do cannot be performed by anybody else. So when such things happens, then legal representatives or a promisee cannot demand the performance of the contract from the promiser, right? Similarly, if the performance of the promise by the promiser is of personal nature to promisee, then the legal representative cannot demand the performance. For example, the contract of wedding, like there is a contract which we call nikah between wife and husband. When wife dies or when husband dies, so the legal representatives of both cannot marry each other, right? Because here the contract is of a personal nature. With the demise of one of these, the contract is void. There is an example: Ahmad bought rice from Bilal. Bilal died before the recovery of price. Now here the legal representatives can demand the performance because this is not something of personal nature. Third party, as I said earlier, it's a very rare case. there are very rare cases where a third party can also demand the performance of a single promise contract from the promisor, right? And the rare case is when the contract is between A and B is made for sole benefit of the third party, for the sole benefit of the third party, then the third party can demand the performance, because yes, in previous lecture we discussed that the consideration may move from promisee to the third party. So in a contract where consideration moves from promisee to third party, then in such exceptional cases the third party can also demand, but that third party should be the beneficiary, the sole beneficiary of the contract. As a result of the performance of this contract, the sole benefit should be to that third party. There are multiple examples. For example, the municipality, Kabul municipality, they give contract to construction companies for the benefit of a district. For example, District 4, the road should be constructed, so a construction company takes the contract from the municipality Kabul Sharwali. So in case of any breach of the duty from the construction company, the local people from that district can demand the performance from the construction company. The construction company cannot deny their demand, right? Because the contract is for sole benefit of those the local people from that district. There is another example here. Ahmad transfers some property to Bilal under the trust for the benefit of Mahmoud. So here, see, A and B has a contract, but A has no benefit here. The benefit of M, who is the third party, is basically the benefit of A. So in this situation, the consideration moves from A, who is the promisee, to M, who is the third party. So Bilal has promised that he will benefit Mahmoud, and because of this promise, Ahmad has transferred him some property. So later on, Bilal cannot deny, cannot reject, or has to perform his promise. If he does not, then Mahmoud can demand the performance, but it should be through the court of law. Like we cannot take the law into our hands and break the law. So that's about the single promise. Now, what about the performance of the joint promises? Before we talk about the performance, let's talk about what does joint promises contract mean. So when a contract, there are two or more than two people enters into a joint agreement with one or more people, such a contract is called joint promises. Means that on one side there are two people who has jointly promised to either one or more than one promises. Means there should be at least two promisers, right? In a contract where there are at least two promisers who jointly has promised to one promisee or to more than one promisees, such a contract is called joint promises contract. So again, there are two questions: who should perform first and who can demand the performance? So definitely the promiser has to perform first, and the promisees and the legal representatives of the promisees can demand the performance of the contract. So let's talk about how promisee can demand the performance. When a promise is made with several persons jointly, then in the absence of any agreement to the contrary, all the promisees jointly can demand performance, and single promisee cannot demand performance. When there is one promiser and he has promised to one or more than one people who are promisees, this is a joint promise contract. Also, second case, there are two people who has jointly promised to one or more promisees, this is also the joint promise contract. So in case if there is one promisee and there are three promisees, for example, now here three promisees all together can demand the performance from the promiser or promisers. If one of the promisees is not absent, two of the rest cannot demand the performance from the promisers. So this is a condition from the law that altogether all the promises, if it is two or more than two, they can jointly demand the performance from the promiser or the promisers, right? So there is a technical thing in this contract. For example, Arshad borrows 400,000 from John and Campbell. Only John and Campbell can demand the performance jointly. If John has agreed to demand the performance and Campbell does not, in such cases John alone can demand the performance of paying back the $4,000 from Arshad. So both have to agree and jointly should demand back the borrowed money from Arshad, right? So legal representatives, in case of the demise of the promises, the legal representatives can demand the performance. Now there are different cases. For example, there are three promises and two promisers, right, or one promiser. What if one of the promisees has died and two promisees are alive? So what will happen now? The law says that they all together have to demand the performance from the promiser. So what will happen here? Two promisees who are alive, they will get together with the legal representative of one of the promisees who has died. So they three all together now can jointly demand the performance of the contract from the promiser, right? If one of the promisee is alive and two the promisees has passed away, so the legal representatives of those two people, promisees who have passed away, can join together with the alive promisee and they can jointly demand the performance of the contract from the promisers, right? Promiser or the promisers. So only in joint promises, only the legal promisees and the legal representatives can demand the performance. Third party cannot demand. Third party is only in the first category, which was a single promise contract. So and I explained to you how the performance should happen in single promise and also in the joint promise. Now we have a third category, which is performance of reciprocal promises. What is a reciprocal promise? A contract in which the consideration of one party is the consideration of other party is called the reciprocal promise. Means there is one promise from one side and the same promise is made from the other side. So the promise made by one party is the consideration of the other party, and promise made by the other party is the consideration of the first party. Means there is a promise against a promise, similar promise. In other words, you can say a contract consists of reciprocal promises when one party makes a promise in consideration of similar promise made by the other party. So we say reciprocal, right? So reciprocal promises have three structures. The first structure is mutual and concurrent. The second structure is mutual and independent, and third structure is alternative promises being illegal. Now mutual and concurrent, from the name mutual means from both sides, concurrent means should happen together. Mutual and independent. Mutual means from both sides, independent means one promise should be fulfilled independently than the other promise. In one side should perform their fulfill their promise independently without waiting from the performance of the promise from the other party. In alternative promises, here it's a different situation. It's also mutual promise from two sides, but from one side there are alternative promises. Two alternatives have been given against a promise from the first party. So and one alternative is legal, the other alternative is illegal. So only the legal portion can be demanded, illegal portion cannot be demanded, right? For example, Ahmad has a promise to Bilal, but Bilal, against Ahmad's promise, Bilal has given two alternative promises. of which one promise is legal, the other is illegal. So now Ahmad can only demand the legal portion, the legal promise. The illegal promise cannot be demanded. So in such cases we don't have to be deceived by the illegal portion. We have to look at the legal portion, and based on that we have to make decision either we have to enter into the contract or not. So now let's talk about these three structures of the reciprocal promises in details. Mutual and concurrent. In case of two promises performed at the same time, the promissory may not perform his promise unless the promisee is ready to perform his reciprocal promise. In mutual and concurrent situation, neither promisor can demand the performance nor the promisee can demand the performance. Both promisor and promisee have to get ready, or they should be mentally ready to perform their promises simultaneously at the same time, right? So promisee cannot demand the performance from the promisor until and unless he himself is ready to perform his part of promise. Similarly, promisor cannot demand the performance. Similarly, the promisor cannot demand the performance from the promisee until and unless promisor himself is ready to perform his part of promise. So it means that in such situations where there are reciprocal promises and the nature is mutual and concurrent, both of the parties have to and should and must simultaneously perform their part of promises at the same time. Okay, mutual and independent. In this case, each party performs his promise independently without waiting the performance of the other party. So we will have to look at the situation now. If we look at the situation, we look at the promises. If the promise of one party is to be performed first logically and by the situation, then that party has to perform his part of promise first and the other party has to perform second, right? So here we will look at the scenario, we will look at the reality. Based on that, the performance of the contract should happen. One should perform his part of promise, the other should perform his part of promise without waiting for the performance from one another, right? Now hope it's clear. Next we have alternative promises being illegal. It's another structure of the reciprocal promises. In case of an alternative promise, one branch of which is legal and the other is illegal, the legal branch alone can be enforced. So for example, A agrees to pay 1 lakh Afghani to B, for which B shall deliver either rice or opium. So here from one side there is a promise for the payment of 1 lakh Afghani, but from the other side there is a promise of delivering either rice or the opium. Here there are two alternatives, rice or opium. So rice is legal portion, opium is illegal portion. Here if something goes wrong, if there is disagreement between the parties, so in the court of law only the legal portion, which is rice, can be demanded by A to be performed by B. The illegal portion cannot be demanded, right? So that's all about for today's lecture, which was about the performance of the contract, once again let's review. When it comes to performance, we'll have to look at the promises in that agreement or contract. It could be a single promise, it could be a joint promise, it could be a reciprocal promise. Single promises. In single promises, promisee, legal representative, and on some exceptional cases, third party can demand the performance. And joint promises, only promisees and the legal representatives can demand the performance jointly, not single, not one by one, but by jointly. Then we have reciprocal promises. Reciprocal promises are of three structures: mutual and concurrent, mutual and independent, and alternative promises. Here, mutual and concurrent, they should be performed simultaneously at the same time by both of the parties. Mutual and independent, here we will look at the situation and decide which promise should be performed first and which should be performed second, and one party should perform his part of promise without waiting to the other party to perform. And then we have alternative promises. In this situation where one party has a promise to other party, and other party has a promise, but this promise has two options, of which one option is legal and other option is illegal. So here in this case only legal option can be performed, and the demand of performance can happen for the legal part, not for the illegal part, right? So thank you so much for being with me. Inshallah, I'll see you in next lecture, which will be about the breach of contract.